Good afternoon. Welcome to another edition of Legal Access. We get together each and every Thursday morning, 11:30, to give you 30 minutes to ask all the questions you want to ask about our topic of the day. Today it's premises liability. If you don't know what that means, it means if you get injured on somebody else's premises, what kind of rights you have, what you should do and what you shouldn't do. If you have any questions about a slip and fall accident, trip and fall accident, anything like that, today is the day to get those questions answered. Give us a call. The number is on your screen. We'll answer those questions for you over the next 30 minutes. Here on our panel to answer those questions from the McGuire Law Firm is Ian McGuire.
Good to see you, Dave.
Also from McGuire Law Firm, Tiffany Buffkin. And to your left on the very end, we've got Rick O'Neill from the O'Neill Law Firm.
Good morning, everybody.
Great to see Rick with us, and of course Tiffany. Tiffany's the one that she's always working and doing depositions and stuff. So we're over here doing the show, and so it's nice to have her here with us. But Rick handles, of course, these cases, which premises liability, which is our topic today, and his firm does. Rick's background actually was as a law enforcement officer, so he actually does personal injury, but he also does criminal defense as well, and he offers a neat perspective both in the criminal field and handling personal injury cases. So, you know, as we mentioned, today's topic is premises liability. But if you want to give us a call on anything that you know our firms handle, feel free to do that. Personal injury, workers' compensation, or even if you have a question for Rick on criminal defense, you give us a call at 843-848-8080. That's 843-848-8080. Right, Dave?
Absolutely. And as far as premises liability is concerned, we've got a really good chance of rain from that tropical system that's out there this weekend. Friday, Saturday, and Sunday could be very wet. So if you're out and about, you're going into a store and you walk into the threshold of the store and you notice that it might be a little bit damp or wet on their tile floor, you slip and fall, what kind of liability does the premises have for you having an accident on a weekend like this, or any time anytime they might slip and fall?
You want to start?
Yeah, so with premise liability cases, just because you're injured on someone else's property does not always mean that you have a claim against the owner. So unless the owner has done something negligent, failed to clean up, you know, a puddle of water that they knew about or they should have known about, then there's probably not going to be a claim against the owner. You know, with rain, unless maybe if they don't have floor mats, they don't have wet floor signs, or there's, you know, rain being tracked in that's left for a substantial or reasonable amount of time. Then usually with inclement weather, everybody kind of knows that it's been raining, so it's important to be safe whenever you're out in the stores. But there would have to be some type of negligence on the store owner in order to pursue a claim based on rainwater.
And we always use the example, you know, with a supermarket. If I was walking and I spilled my water, and Rick or Tiffany was coming behind me at some point and slipped on that water, there's not necessarily a case unless the premises holder had knowledge and just ignored it and left the water there. And you know, an unreasonable time went by without them cleaning their floors. Otherwise, they wouldn't be responsible. Just because, as Tiffany said, just because something happens, you know, I think there's a case. The premises is not the insurer of the safety of people in the store. Having said that, they do have a responsibility if they're making money off the public and to keep the premises in a reasonably safe condition. So it's usually on a case-by-case basis that you determine if there's a case or not.
Yeah, and just to highlight the case-by-case basis, because I know everybody gets irritated with attorneys, that our favorite question is, well, it depends. But even with the example that Ian just gave, you know, if he's a customer and he drops water, the duty is different that the store owner owes, where as opposed to if it is a manager, an employee who drops the water.
Right.
And the you know, the store, the grocery store is going to be negligent. They're going to be responsible for the negligence of their agents and employees. So there's a different standard if the dangerous condition was created by an employee of the store as opposed to a customer. So really, anytime you're injured on someone else's property, our law firm does, we will do a free consultation to talk about the facts of the case. I know Rick's law firm offers free consultations as well. So I always think that it's important to at least call and talk
Right.
about your case with an attorney, because it truly is very fact specific in regards to premise liability cases.
Yeah, the three prongs, as Tiffany touched on, is, one of these can apply if they created a dangerous condition or their employees, that would be one, or if
Yeah.
they knew of a dangerous condition, did nothing about it, or if they should have known, which is probably
Yeah.
the hardest out of the three maybe to demonstrate. But there are cases where they should have known and they just didn't take even a iota of care, and as a result somebody was injured, so there would be a case. So as Tiffany said, it really comes down to the facts on every case, right, Rick?
Right. I mean, on one end of the spectrum, using the water on the floor case, this was a South Carolina case, a big box store. There was a cashier sitting there 10 feet from where the water was on the floor. Someone slipped in that water, and the South Carolina Supreme Court said, that the plaintiff could not prove that someone from the store is deposited that substance on the floor, or that they knew or should have known, and that case got thrown out. And now that's on one end of the defense, from the defense side, and there's other cases that,
Are helpful.
Yeah.
to the plaintiff. But I mean, that's how bad it can be as far as the burden of proof in proving these cases.
Yeah.
Let's go ahead and start at the beginning. If you're in somebody else's premises or in a store and you do injure yourself, whether it's a slip and fall, trip and fall, you go to the manager or the owner of that. What is their responsibility to you as the owner or manager of the facility?
Well, I mean, I think the diligent and the empathetic thing to do is to make sure the person is okay. I would tell them to fill out a report and be as accurate as possible. I think it's if the person's not very seriously injured, they might be able to read the report and make changes or sign it. But I think the more communication between the parties, the potential parties, the better it is. A lot of cases where there's injuries on the premises don't have to result or don't in necessarily in litigation or even a claim, so to speak. Most premises have insurance that's no-fault insurance. And so say you just had minor medical bills, you had to go to the hospital or something, but you were okay in a couple of weeks, there may be insurance that'll pay your bills and potentially even pay if you had some lost wages. It's when it gets more serious and injuries, you've torn something or you broke something, you need a surgery, where it gets more problematic, and maybe then it turns into litigation. But if there's a video, I think the owners would be, no matter what it shows on the video, I think they should have a duty to keep that. And if they have any understanding that there could potentially be a claim,
Right.
that would be something they should do,
Yeah.
right?
And just from a practical standpoint, if somebody reports that they were injured, it would be important for the employee to remedy whatever the issue was, whether it's water, if there's something wrong with the curb or the sidewalk, definitely document that and report it. Make a note of it that someone was injured, this needs to be fixed.
Right.
A large component of premise liability cases is that it is in the public's best interest, and there's a public policy perspective from bringing lawsuits, because it encourages everybody to keep public spaces safe. And so one thing is that as a store owner or as an employee, if you have noticed that there's a dangerous condition, definitely document it, report it, and
Right.
go ahead and make repairs so other people are not injured.
Good point.
How damaging is it to an owner or a business manager or something like that if one of their employees or they go over to somebody who's just hurt themselves and they utter something like, "Oh, I know we should have fixed that," or "Oh, that people trip on that all the time."
Yeah, so it's definitely a admission of of a party opponent in litigation. So things like that. But again, I mean, you know, if people have been injured before with this condition, it should be fixed. And I think that that's something that, from our perspective, if it's documented, you know, certainly helpful to us. So.
Right, goes to prove notice. In these premises cases, it always goes to notice. They knew about it or they should have known about it. And you have to get over that hurdle. Doesn't matter how badly injured someone is. If you can't meet that burden of proven notice, then your claim is subject to being dismissed by a judge.
All right, tell you what, we're going to run to a break. When we get back, we would love to talk to you. If you have any questions about premises liability, slip and fall accidents, trip and fall accidents, today's the day to get those questions answered. Call us. The number is on your screen. It's Legal Access, brought to you by the McGuire Law Firm. Welcome back. It is Legal Access, brought to you by the McGuire Law Firm. Today our topic is premises liability. If you had a slip and fall accident, trip and fall accident, any kind of accident on somebody else's premises, whether it was at a pool, an amusement, anything like that, give us a call here today and ask your question. We'll be happy to answer that. On the panel here today to answer your questions, Ian McGuire, also Tiffany Buffkin, both from the McGuire Law Firm, and Rick O'Neill from the O'Neill Law Firm. The phone number is on your screen. Call us here today. Now, we've talked about slip and falls. As far as trip and fall accidents, if we go back to the same kind of scenario, if somebody goes into a store and they trip over, like there's a floor mat that maybe the edge of it has been turned over or something like that, it's dog-eared, and they trip over that because the person behind them who was walking accidentally did that. Is that any kind of a case, or is that something that is going to say, well, you know, the premises was unaware that anything was wrong?
I've actually had that very exact set of facts. That's going to be a more problematic case. Something where the dangerous condition just happens instantaneously and then there's an injury. Those are harder to prove because, again, it goes back to proving notice to the store. So in that case, unless there's more, I mean, that's going to be a big hurdle to get over. You have to prove that notice. Now, if that mat had been like that for a half an hour and nobody did anything to it, I mean, the people that are working at the store should be on the lookout for something like that and should go correct it. You know, if they're not going to do it, call maintenance, call a manager, do something. So it's a fact-specific analysis for each and every one of these injuries.
And then you look at the mat. Is it the safest kind of mat? Could there be a different kind of mat that would have been safer and could have been done at a
Is the mat old and prone to flaring up on the edges like that?
Right.
Or is it, you know, a brand new mat in perfect condition and just, you know, some other customer did it, and you know, it's a tough situation if something like that happened to you. But, you know, also as the customer, you have a duty to watch where you're walking and to observe stuff like that yourself and to avoid injuries and trip and falls individually yourself. So that analysis always comes into it. A lot of times the court will ask the jury, if it ever gets that far, to put a percentage of fault. You know, what percentage of fault goes to the premises, the store, and what percentage goes to the claimant, the plaintiff.
Yeah, unlike a car wreck, Rick makes a great point where you get hit from behind, and when we get to court, inevitably the defense will say they'll take responsibility for liability. Of course, the next word is but, and then they say why the injuries are not the fault, the causal connection to the accident. But with these type of fall cases, almost every case, they're going to deny liability and say it was open and obvious, as Rick pointed out, like, because that's a defense. If it's you should have seen it because it was so open and obvious. But you know, the return to that from the plaintiff's standpoint is you had control over the area, and as the premises owner, and you had more knowledge than somebody that's walking on their maybe for the first time or the second time. So
yeah, I think that's a hard argument sometimes to make with open and obvious, that, you know, me as a customer, I should have noticed it within 20 seconds of car approaching, but the business owner, you know, didn't have knowledge of it. especially if you're talking about situations like potholes, crevice or voids in the concrete and things of that nature. So the open and obvious certainly can be a double-edged sword
Right.
for both
100%.
parties.
Yeah.
And the open and obvious also, that's very fact specific, because if the business owner had a reasonable expectation that me as the customer
Right.
would be distracted, like in a grocery store, of course you could be watching where you're going, but nobody's staring straight down at their feet. That actually probably would be more of a hazard, because now
Yes.
I'm running into other customers
Yeah.
and, so sometimes the business owners still, they still have a duty to kind of anticipate, what are my customers doing here? Is it a situation where there's kind of a lot of hustle and bustle and it's busy and the customer is expected to be distracted? In those situations, the open and obvious defense is not going to have as much merit than, if you're walking in a library and it's kind of a slower pace. And
Well,
less
speaking of
busy.
watching where you're going, and you mentioned concrete, what if you're walking down a sidewalk and the sidewalk's raised because of tree roots or cracked because of roots? You trip over that. Is the municipality, the city, or the county responsible for that, and how does that complicate things?
Yeah, so I think that anytime it's a sidewalk case, those usually, most of the time will result in litigation, because there's generally multiple parties who are either responsible, or one party that is responsible is going to kind of point the finger at somebody else and say, well, this is the city's sidewalk, even though it's a condition on the premise owner that's causing the issue with the sidewalk. And a lot of that still comes down to notice and how long it's been in that condition, and whether it should have been repaired. Is it a dangerous condition? And usually with sidewalk, that kind of rolls into the South Carolina Tort Claims Act, that if it is a situation where you're going to have to file a lawsuit or make a claim against the municipality, then you're limited in what you can recover,
Right.
and the timeline to initiate your case is different than if it was a private entity.
Yeah, and I don't know how many, but more than once I've been in a trial where the defense will say, when you were a child, what did your parents always tell you? Watch where you're walking. But they don't tell you to stare down at your feet while you're walking, because as Tiffany pointed out, you have to, we've had to have experts sometimes for this. Like it's such a simple germane, but when you're walking, you're actually looking all around you, right? You're not staring down at the ground. You probably have more injuries that way. So, but that's inevitably what they'll say, and that's what the insurance company lawyers usually will try to point out to the jury.
Yeah.
Premises liability, that's our topic here today. We still got about 10 minutes left in the show, so if you want to be on our final segment, call us now and we'll get you on in just a couple of minutes here and get your questions answered about premises liability. It's Legal Access, brought to you by the McGuire Law Firm. Welcome back. It's Legal Access, brought to you by the McGuire Law Firm. If you have any questions today about premises liability, if you've been hurt on somebody else's premises, make sure and give us a call. We've got about 10 minutes left in the show. We'll be happy to get you on and get your question answered here today on Legal Access. As far as somebody's premises are concerned, like outside the premises, like parking lots and places like that, is it the business owner's responsibility to keep you safe there as well?
Well, sometimes those areas may be a part of a development, a strip mall or something, and there may be a property manager in charge of that. But other times the big box store may have a dedicated part of the parking lot that's their responsibility. So again, it's a case by case basis. And when we talk about property managers, it seems like all these type of slip and falls generally also involve a property management company. There's maintenance people, there's a property manager, and there's different layers of liability. That's why these things do end up in lawsuits, because you have people pointing the fingers at each other as to who really dropped the ball when there was a dangerous condition. So I mean, I think as the premises lessor, you should definitely take those type of things into consideration and report it to, and then you go back and look at the commercial lease. Who's responsible? But I'll also tell you this: when there is an injury, just because there is a lot of finger pointing generally, as a plaintiff's attorney, we generally identify any possible defendant and just sue everybody. It's because inevitably that's what's going to happen.
Yeah.
And you don't want to be left at trial with the defendant pointing the finger at someone that's not there at trial to answer the accusations.
And essentially saying plaintiff messed up by not suing that person. They're really
Why are they not
responsible.
here?
So
Yes.
it's easier to sue them, and then, and I don't know. I try to, I realize there's a burden, and it's when somebody gets served with a lawsuit and they're not responsible. So I really think that it's incumbent on a plaintiff to do an investigation and not frivolously sue somebody. But the flip side is, as Rick said, you have to be so careful and you have to zealously represent your client and make sure that nobody's missing. And what ends up happening if you sue anybody that is potentially might have a hand in the negligence, then it usually gets worked out before it ever gets to trial of who the real responsible parties are through discovery.
And sometimes there's not just one party that was negligent. Actually,
Absolutely.
I think most of the time there's multiple people who have kind of dropped the ball. For example, in your question about a big box store, like if you use Food Lion, for example, generally Food Lion is gonna, the parking lot is gonna be considered a common area between, whoever actually owns the property. And so a common defense for the big box store is, oh, well, you slipped outside, or there was a huge, pothole outside. Well, we don't own that. Okay, well, that your customers, this is the exclusive entry into your store. You are making money off of these customers coming in. So even if the responsibility of ownership doesn't fall back to the big box store, if you know that there's a dangerous condition, they have some sort of responsibility to report that to whomever they're claiming is responsible for making the repair. So in those types of situations, even if the ultimate ability and responsibility to repair the dangerous condition in the common area would fall down to the landowner or the property management company, the big box store who is inviting their guests to come in through this way also has a duty to at least make the owner aware that there is an issue and it needs to be repaired.
And follow up.
Yeah,
if they don't do
absolutely.
anything, hound them to fix it.
Before we get to the end of the show, see if we can fit one more call in here. Alexa's in Myrtle Beach. Hi, Alexa. Thanks for calling in today. What's your question?
Hi, my question is if there's any liability for an apartment complex who has elevators down for over 40 days?
Well, I mean, if somebody was injured because of something wrong with the elevator, there might be, there may be contractual issues between the apartment complex and the elevators or the homeowners that, I guess potentially that could be the case, right?
And that the Landlord-Tenant Act may also be a legal standard that you would have to file suit in like magistrate's court to get them to provide the services that is part of the lease.
Yeah.
Well, Alexa, hopefully that answers your question. If you have any further questions, and everybody out there, if you have any questions about premises liability, as Tiffany mentioned earlier, consultations are free for premises liability cases, so don't hesitate to pick up the call and call an attorney to find out whether or not you've got a case. All right, next week when we get back together, real estate is going to be our topic. So if you have any questions about real estate, next Thursday, 11:30, is going to be your time to shine. So we'll see you then. I want to thank our panel here today, of course, Ian McGuire, Tiffany Buffkin, both from McGuire Law Firm, and Rick O'Neill as well. I'm Dave Priest. Next week, real